This year's Ella Conference is appreciative of all of our sponsors. Our presenting sponsor, Gallagher. Our gold sponsors, the Arkansas SHRM chapters of NOARC and CARA, Windstream, Cross Gunner Witherspoon and Gauchus, and Wright Lindsay Jennings. Our silver sponsors, SFLIC, Consolidated Admin Services, Friday Eldridge and Clark, and the West Central Arkansas SHRM chapter. Our bronze sponsors, First Staff and the Human Resources team. Now, let's hear a special welcome from Jane Kim with Wright Lindsay Jennings.
Hi, everyone. My name is Jane Kim, and I'm a partner on the Labor and Employment team at Wright Lindsay Jennings. Our firm is proud to sponsor the Ella Conference and to have guest speakers involved at the event as well, including WLJ attorneys Stuart Jackson, Michelle Kammerling, and Shelby Howlett. We hope the information that you learned today is valuable and timely. I'd like to share a little bit about the firm for those of you who aren't too familiar. WLJ is a full-service firm with offices in Little Rock and in Rogers. We have 68 attorneys who can help your business with everything from corporate and transactional issues to complex business litigation to government relations services like regulatory compliance and legislative drafting. Our experienced team of labor and employment attorneys is prepared to guide you through all aspects of the employer-employee relationship. Between the other members of the team and myself, we help clients with COVID policies and procedures, medical marijuana-related HR policies and practices, employment and civil litigation, civil rights claims, governmental agency investigations, wage and hour compliance and investigations and litigation, including class and collective actions, internal investigations, and labor management relations. We can also help you with day-to-day workplace matters, such as employee handbooks, agreements, and disciplinary issues. Our attorneys have extensive litigation experience, but do place a premium on preventing employee claims that could lead to investigations and litigation. Our labor and employment team also provides many resources to the HR community, including quarterly free lunch and learns and webinars with HRCI and SHRM credit, e-newsletters, website articles, and email alerts on pertinent legal issues, and on-site or virtual training on a variety of HR topics. Thanks again for allowing us to be a part of the Ella Conference. And please visit our website at www.wlj.com to learn more about how we might help your HR department.
Hello, and thank you for viewing this webinar today. I'm Audrina Lange, the Community Outreach and Resource Planning Specialist for the Department of Labor's Wage and Hour Division. And part of my job is to make sure that workers know about their rights and protections under the laws that we enforce, and employers know about the obligations that they have under the laws that we enforce. And the laws, one of the laws that we enforce is the Fair Labor Standards Act, or the FLSA, and it affects nearly all employers and employees in the U.S. So to give you some scale, that's roughly 10 million establishments and 148 million workers across the U.S. Of course, we also enforce a number of other labor standards, such as job-protected leave under the Family and Medical Leave Act, labor provisions within temporary visas, migrant worker protections, maximum wage garnishments under the Consumer Credit Protection Act, and pay and leave requirements in service contracts and construction contracts with the federal government. In fact, the whole mission of the Wage and Hour Division is to promote and achieve compliance with the labor standards to protect and enhance the welfare of the nation's workforce. We work toward that mission through enforcement as well as outreach and education, just such as this. We have more than 200 offices nationwide, and our staff can accommodate most languages through either staff or the use of translation services. We want workers and employers alike to be able to access the resources and protections provided by the Wage and Hour Division. It's important to note that the Wage and Hour Division enforces labor laws for all workers, not just U.S. workers, but all workers in the U.S., regardless of immigration status, and we don't ask for immigration status when we go out and do investigations or when we take complaints. Wage and Hour has been and continues to be open and working to achieve our mission. So to put our work into context, here are a couple stats for you. In the last 5 years, we've helped more than 1.3 million workers, and we've collected more than $1.4 billion in back wages. As I mentioned a few minutes ago, our mission is to promote and achieve compliance with labor standards in order to protect and enhance the welfare of the nation's workforce. That's a big job. We've accomplished a great deal in helping millions of workers and collecting billions in back wages, but there's still a lot of work to do. And we get that work done by educating workers about their protections and helping them assert their rights, as well as by helping employers understand their responsibilities under the laws and leveling the playing field by enforcing labor standards. Today's presentation focuses on the Fair Labor Standards Act, which establishes requirements for minimum wage, overtime, child labor, and record keeping. And even more specifically, I'll be covering compensable time, including an overview of the Portal to Portal Act, and some of the most common issues and topics related to hours worked. The first thing we need to address before anything else, though, and something that we will always address first, is the issue of coverage. So under the FLSA, coverage can be either enterprise-wide or individual. Enterprise-wide coverage entitles all the employees to FLSA protections. On the other hand, individual coverage is limited to each employee's activities on a work week by work week basis, and it's determined on their specific activities. Enterprise-wide coverage can be asserted when businesses are engaged in interstate commerce with at least $500,000 in sales and at least 2 employees. Enterprise-wide coverage could also be asserted for certain named enterprises, regardless of their sales or business volume. These include hospitals, nursing homes, schools, preschools, and public agencies. Individual coverage, as I mentioned, is determined by each worker's activities and is determined on a work week by work week basis. Individual coverage can be established in those work weeks in which an employee is engaged in interstate commerce. This can include making out-of-state phone calls, receiving interstate mail or emails, ordering and receiving goods from out of state, and running credit card transactions. It's really important to note that nonprofits are also subject to enterprise-wide coverage, but only for those activities performed for a business purpose and if they meet the $500,000 in sales. Income such as donations for charitable activities don't count toward establishing that coverage. Nonprofits may also have individuals who may meet the requirements for coverage under the FLSA, even if enterprise-wide coverage can't be established. So now that we've established the Wage and Hour Division can only enforce the Fair Labor Standards Act for those businesses or individuals covered, let's talk about what counts as hours worked. The FLSA generally defines employ as including to suffer or to permit to work. Typically, work will include all of the worker's time that is controlled by the employer and that is for the benefit of the employer. The FLSA, however, does not explicitly define work. So that's what we're going to talk about here today. In 1947, Congress passed the Portal to Portal Act. This Portal to Portal Act of 1947 established that employers don't need to compensate employees for time spent commuting to and from work. It also provides that certain activities that are preliminary or postliminary to principal activities are not compensable unless they are recognized by contract, by custom, or by practice. For those preliminary and postliminary activities that are compensable, they must be engaged in during the portion of the day with respect to which it is made compensable by contract, by custom, or by practice. And only the amount of time allowed under the contract, custom, or practice must be counted as work time. The Portal to Portal Act does not affect the calculation of hours during the workday, and it does not affect any activities that are integral to the workday or to principal activities. So you can begin to guess that the topic of hours worked is much more complicated than it appears on the surface. The bottom line, though, is that there is absolutely no way for an employer to determine if they are complying with the Fair Labor Standards Act unless they can recognize what counts as hours worked and then compensate employees properly for that work. So let's talk about some common issues that we see with hours worked. We'll start with waiting time. Whether waiting time counts as hours worked really depends upon the particular circumstances involved. Was the employee engaged to wait, which is work time, or waiting to be engaged, which is not counted as work time? So for example, a firefighter who plays checkers while waiting at the firehouse for an alarm is working during those periods of inactivity. The firefighter is engaged to wait. Therefore, that time has to count as work time, even though the employee is allowed to leave the premises or the job site during periods of inactivity. On the other hand, periods during which the employee is completely relieved of duty and that are long enough for the employee to use the time effectively for his or her own purposes are not hours worked. This would be true, for example, if the employee has been told in advance that he or she may leave the job and will not have to return again until a definitely specified time. And then we're going to talk about on-call time, and that's similar to waiting time in that the particular circumstances affect what has to be counted as work time. Employers frequently ask employees to be on call. And if the employee is required to remain on call on the employer's premises or so close that they can't use the time effectively as their own, then that must count as work time. And it must be paid properly. In some cases, on-call employees are required to carry a cell phone or leave word with the company officials where he or she may be reached. If an employee who is on call is free to come and go as they please and engage in personal activities during idle times, then that on-call time is typically it does not have to be counted as work time. The on-call time is usually not hours worked and does not need to be paid unless and until the employee actually responds to a call back to duty. However, if such calls are so frequent that the employee is not really free to use their time as their own, then the intervening periods from when they're taking calls and not taking calls would have to be counted as work time. So we're going to talk now about rest and meal periods, and this is arguably some of the largest issues we have with hours worked. Let me start by saying there's nothing in the Fair Labor Standards Act that requires employers to allow employees to take meal periods or give them rest breaks. However, if they do allow for meal periods and rest breaks, they must compensate properly for those. So for rest periods or short durations of 20 minutes or less usually, These are common in the industry, and they are customarily paid for as working time. Short periods must be counted as hours worked, therefore. If an employer does not want employees to take breaks, the employer must enforce that policy. If an employer allows breaks but does not allow extended breaks or more than 1 or 2 breaks during the workday, the employer must enforce their policies. An employer must pay for break periods if they allow employees to take them. An employer may require employees to clock out and back in for breaks. However, the act of clocking out does not take away the employer's obligation to pay for that break time. Now, bona fide meal periods are a bit different. They're usually 30 minutes or more, and they generally don't have to be compensated for as work time. The employee, though, must be completely relieved of duty for the purpose of eating that meal. The employee is not relieved if he or she is required to perform any duties, whether active or inactive, while eating. And we see this often. It's usually a worker who eats at his or her desk and continues to do work while eating, answering the phone or responding to customers, or a care worker who must respond to any client needs during meal periods and cannot be completely relieved of duty. If an employer has a policy that employees must take meal breaks during the workday, the employer must properly enforce those policies and must allow those workers to be completely relieved of duty during the meal period for it not to count as hours worked. So now we're going to talk a little bit about training time. And there are 4 requirements for training time not to count as work time. It must be outside of regular working hours. It has to be voluntary. It can't be job related. And the employer can't be doing any productive work while they're in the training. All of these must be met. And some of the most common questions we have about counting time, training time as work time, involves voluntary attendance and whether or not a meeting is job related or training is job related. Attendance is clearly not voluntary if it is required by the employer. It is also not voluntary if the employee is led to believe that the present working conditions or continuance of employment would be adversely affected if they do not attend. The training is directly related to the employee's job if it is designed to make the employee handle his or her current job more effectively, as distinguished from training the employee for another job or for a new or additional skill. So for example, time spent by a computer programmer in a course on programming that is given by the employer is hours worked. However, if the programmer takes a course in accounting, it may not be directly related to the programmer's current job, and thus the time the programmer spends voluntarily taking the accounting course outside of regular working hours may not be counted as working time. If employees on their own initiative decide to take independent classes at a school or a college or a trade school after hours, that time is not work hours, and their employer, even if the courses are related to their job, do not have to pay for that work time, training time as work time. So we'll move on to travel time. And this is where we get a lot of questions usually about what counts and what doesn't count. So travel between job sites during the workday is work time. If the employee is required to report to a meeting place to receive instructions, perform other work there, or to pick up equipment or tools, the travel from the designated meeting place to the workplace is part of the day's work. And it has to be counted as hours worked and compensated. The same thing is true for the end of the day. If the employee is required to return to the employer's office or job site the travel time back to the office is counted as hours worked. So for example, if an employee normally finishes his work at 5 p.m. and is sent to another job, which he finishes at 8 p.m., and is required to return to his employer's premises, arriving at 9 p.m., all of the time is working time. However, if the employee goes home instead of returning to his employer's premises, the travel time after 8 p.m. is home to work travel and would not have to be counted as hours worked. There are special rules that apply when employees travel away from their home community. Travel for a special one-day assignment in another city is not ordinary like home to work travel. Because it's performed for the employer's benefit and at the employer's request, it is like travel that is all in a day's work. The normal home to work travel time may still be deducted though. When an employee travels away from home and stays overnight, the travel time is work time when it cuts across the employee's workday. And that employee is simply substituting travel for other work duties. The time is not only hours worked during regular working days, during normal working hours, but also during the corresponding hours on non-working days. For example, if an employee regularly works from 9 a.m. to 5 p.m. from Monday through Friday, the travel time during these hours is work time on Saturday and Sunday as well as the other days. Regular meal period time is not counted. As an enforcement policy, the Wage and Hour Division will not consider as work time that time spent in travel away from the home outside of regular working hours when the employee is riding as a passenger on an airplane, a train, a boat, a bus, or an automobile. So anytime they're riding as a passenger and it's not cutting across their working times, then we would take a non-enforcement approach. So sleep time. The rules for counting sleep time as hours worked are different depending on whether the sleep time is for during shifts that are less than 24 hours or 24 hours and more. So an employee who is required to be on duty for less than 24 hours is working the entire time, even though they may be permitted to sleep or engage in other personal activities while on duty. Therefore, no sleep time deduction can be taken whenever the shift is less than 24 hours. When an employee is required to be on duty for 24 hours or more, the employer and the employee may agree to exclude meal periods and a bona fide regularly scheduled sleeping period of not more than 8 hours from the hours worked. And that's only if the employer provides adequate sleeping facilities and the employee can usually enjoy an uninterrupted night's sleep. If the sleeping period is more than 8 hours, only the 8 hours may be deducted. Where there is no agreement to the contrary, 8 hours of sleeping time and meal periods must be counted as hours worked. There has to be an agreement in place before any deductions take place for sleep time or meal periods. If the sleeping period is interrupted by a call to duty, the interruption must be counted as compensable time and paid properly. If the period is interrupted so much that the employee cannot get a reasonable night's sleep, the entire sleep period has to be counted as hours worked. So the employer must provide adequate sleeping facilities, and that depends on the particular circumstances, but they generally require access to basic sleeping amenities, reasonable standards of comfort, and a basic bathroom and kitchen facilities. Unlike for live-in employees, the sleeping area need not be private. An employee can usually enjoy 5 consecutive hours of uninterrupted sleep if interruptions occur less than half the time. Note the 5 hours must be all at once, and usually means half or more than half of the time. So for example, can this employee get an uninterrupted night's sleep? A personal care attendant provides home care services to consumer on the weekend. The employee is not paid for the hours between 11 p.m. and 6 a.m., which are considered sleep time. If during the 6 months the employee has worked for the consumer each weekend, the consumer has woken the employee up each night for assistance going to the bathroom, usually once around 1 a.m. and again around 3 a.m. Can that employee get an uninterrupted night's sleep? And the answer is no. The employee does not usually receive and enjoy 5 hours of uninterrupted sleep, 5 consecutive hours of uninterrupted sleep. If over the last 6 months of employment that consumer had only woken the provider up for assistance for going to the bathroom once a week around midnight, then yes, the employee would usually receive or enjoy at least 5 consecutive hours of uninterrupted sleep. So you can see that there's some distinctions there. Just keep in mind that the less than 24 hours, there can be no sleep time deducted, and 24 hours or more, you have to make sure that there's an agreement in place and that the employee can get at least 5 hours of consecutive uninterrupted sleep time. So now we're going to talk a little bit about telework, and I don't have a slide for this. It's important to note that we've talked about everything that we've talked about so far. It counts for work time regularly and for telework. There's really no difference in counting work time in telework and regular in the office work. Last year, Wage and Hour put out some guidance regarding telework and how to count scheduled hours and unscheduled hours of telework. That guidance is Field Assistance Bulletin number 2020-5, and it provides guidance on how the employer can satisfy the obligation to exercise reasonable diligence in tracking teleworking employees' hours of work. If the employer knows or has reason to believe that work is being performed, think back to the work is to suffer or to permit to work. If the employer knows that work is being performed, that time must be counted as hours worked. The employer has an obligation to exercise reasonable diligence in acquiring knowledge regarding employees' unscheduled hours of work. They may satisfy that obligation by establishing a reasonable process for an employee to report uncompensated work time. So the employer must develop this reasonable process for employees to report any unscheduled work time. The employer cannot discourage or impede accurate reporting through that process, or it will become invalid. So let me repeat that. The employer cannot discourage employees from accurately reporting their work hours, including unscheduled work hours, through that reasonable reporting process, or it will become invalid. They won't be able to use that, and they can't say that they exercised reasonable diligence. So given that the employer has exercised that reasonable diligence and has not discouraged workers from reporting accurately their actual number of hours, if the employee then fails to follow reasonable reporting practices to report unscheduled work time, then the employer is generally not required to investigate further to uncover unreported hours and therefore not required to pay for them. And in still talking about telework, we've been asked quite a few questions, and here's one of the most frequent questions. Because of the pandemic, I'm required to telework and perform my normal work duties. Does my employer have to compensate me when I telework? And the answer, of course, is yes. Regardless of where you work, your employer is required to, when they have reason to believe or know that work is taking place, they're required to compensate you for that work. The FLSA requires employers to pay non-exempt employees at least minimum wage for all hours worked, and at least time and 1/2 the regular rate of pay for hours worked in excess of 40 in a work week. In general, salaried executive, administrative, and professional employees must receive their full salary in any week in which they perform any work, subject to very limited circumstances. There are only 7 instances in which bona fide salaried exempt administrative, executive, or professional employees may have deductions from their pay. And of course, the pandemic has changed a lot in the way in which we do business. And we've got some other COVID implications for work time. So one of the other questions that we've received is, my employer requires all employees to take their temperature to try to screen for people who might have COVID-19 before entering the job site. Do I need to be paid for that time in taking my temperature? And the answer is, it really does depend. And I know I say that a lot when people call and ask me questions. It really does depend. Under the FLSA, your employer is required to pay you for all hours that you work, including the time that you begin your normal working hours, if the task that you're required to perform is necessary for the work that you do. So for many employees, undergoing a temperature check before they begin work must be paid because it is necessary to the work that they do. So for example, if a nurse who performs direct patient care services at a hospital is required to check her temperature upon arrival at the hospital before her shift, the time that she spends checking her temperature upon entry to the work site is likely hours worked and compensable as hours worked because such task is necessary for her to safely and effectively perform her job during the pandemic. So in other words, the temperature check is integral to and indispensable from the nurse's job. Other laws, of course, may offer greater protection, federal, state, local laws, but that's what the laws are under the Fair Labor Standards Act. Another question that we've gotten is, what about if my employer requires me to have a temperature check after I've started my workday? And we've already talked about the Portal to Portal Act and hours worked, and time spent during that workday that is taking a temperature would have to be paid because it's during the workday. What about if I'm required to complete a COVID-19 health screening for myself during the workday? Is that time compensable? And the answer is yes. Again, if you're required to complete a health screening during your workday, your employer must pay you for that time. All the time between the start and the finish of an employee's workday must be paid unless it falls within a few exceptions, such as bona fide meal periods and breaks and off-duty time. Specifically, wage and hours regulations require that employees be paid for time spent waiting and receiving medical attention required by the employer during the workday. And the same logic applies to COVID-19 health screening required by your employer during the workday. And yet another question is, my employer is requiring me to undergo COVID-19 testing on my day off before I can return to the job site. Do I need to be paid for the time spent undergoing testing on my day off? Once again, it depends. Under the Fair Labor Standards Act, your employer is required to pay you for all hours that you work, including the time on your vacation day, if the task that you're required to perform is necessary for the work that you are paid to do. So for many employees, undergoing COVID-19 testing may be compensable because the testing is necessary for them to do their job safely and effectively during the pandemic. So for example, a grocery store cashier who has significant interaction with the general public is required by her employer to undergo a COVID-19 test on her day off. That time is likely compensable because it is integral and indispensable to her work during the pandemic. Other laws may offer greater protections, of course, and we've talked about those federal, state, and local laws. And the laws under the FLSA may not be the most stringent. So in addition to these questions, we've also been hearing a lot about hazard pay during the pandemic as well, and we've gotten a lot of common questions about hazard pay from both employers and employees. So if I'm an employee of a private employer that began paying incentive payments such as hazard pay for working during the COVID-19 emergency, do those incentive payments have to be included in the regular rate that is used to compute my overtime? And the answer is yes. Payments your employer provides to you to perform work constitutes compensation for employment, and that must be included in the regular rate, and with very few exceptions. In addition to hazard pay, we've gotten a lot of questions on child labor during the pandemic. So one that we have gotten is, I'm 15 years old. My school has physically closed due to COVID, but it would normally be in season. Am I permitted to work if I cannot physically go to classes? And so we have to think about what does it mean for school to be in session? And in general, for purposes of non-agricultural employment, school is considered to be in session during any week the public school district where the child resides requires its students to attend school either physically or virtually. If a public school district physically closes the schools in response to COVID-19 but requires all students to continue instruction through virtual or distance learning for at least one day or during any part of one day, then school is in session in the school district during that day and that week. If a school is physically closed and the school district does not require virtual or distance learning, the school will not consider to be in session. During any week that school is not in session, minors may not work more than 8 hours in a day or 40 hours in a week. That's for 14 and 15-year-olds. They may also only work between 7 a.m. and 7 p.m. in any one day when school is in session, except during the summer, which is June 1 through Labor Day, when the evening hours extended to 9 p.m. Please also keep in mind that the FLSA includes child labor provisions which prohibit or limit certain occupations for workers under the age of 18. Employers must make sure to abide by the most stringent laws, be it federal, state, or local, when it comes to youth employment. We've also had a lot of questions about how the pandemic has affected provisions in the Fair Labor Standards Act for nursing mothers. Section 7R of the Fair Labor Standards Act requires employers to provide reasonable break time for an employee to express breast milk for her nursing child for 1 year after the child's birth, each time such employee has a need to express the milk. Employers are also required to provide a place other than a bathroom that is shielded from view and free from intrusion from coworkers and the public that may be used by the employee to express breast milk. Employees are entitled to break time to express breast milk if they are employees who must be paid overtime under the Section 7 of the Fair Labor Standards Act. Employees who are exempt from overtime under Section 7 of the FLSA are not entitled to break time under federal law. However, the FLSA requirement does not preempt state laws that provide greater protections to employees. And in fact, the Arkansas state laws require employers to provide break time for nursing mothers regardless of their status or their exemption from overtime. So changes in working conditions, hours, and locations during the COVID-19 pandemic have raised questions about these protections under the FLSA for nursing mothers. And here's one of the questions that we've gotten. Are nursing mothers entitled to reasonable break time and space to express breast milk while teleworking during the COVID-19 pandemic? And that answer is yes. All employers covered by the FLSA must comply with break time for nursing mothers provisions unless they have fewer than 50 employees and can demonstrate that the compliance with that break time for nursing mothers provision would impose undue hardship. Employers are obligated to follow the FLSA break time for nursing mothers requirements regardless of where their eligible employees are located. So you can see that even though the pandemic has changed many things about the way in which we work, it hasn't changed the fundamental concepts of hours worked and the fact that Wage and Hour continues to enforce labor standards. And I'd like to point you towards some of our resources that you may find useful. DOL offers web pages which provide direct access to department-wide resources in one stop. And that's the worker.gov. And it's a site that covers common workplace concerns and federal labor laws that protect workers. And this includes, like I said, department-wide, so not just Wage and Hour, but also OSHA, workers' compensation, and other laws like that. So worker.gov is a good place for workers to go to get information about their rights and protections under the laws that the Department of Labor enforces. And we also have employer.gov. And that's resources for employers, so that employers may go and find answers to common questions about the obligations that they have under the laws that the Department of Labor enforces. In addition, we have the eLaws Advisors, and that's a set of interactive online tools to help employers and employees learn about their rights and responsibilities under all the laws that we enforce federally under the Department of Labor. And as always, you may choose to contact us via our toll-free number, or you can contact me directly at 501-221-4621. Thank you again for your time today.